McGee from Savannah, Judge Armstrong from Memphis, and I'm Judge Golden from Memphis. Are there any announcements or anything we need to address?
No, Your Honor.
All right. You may call the first case.
Dessie X versus Idris X.
Yes.
Okay. Just get started.
Yeah.
May it please the court, my name is Laura Butler from the Memphis and Shelby County Bar. I represent the appellant husband in this case, and I would like to reserve 2 minutes for rebuttal.
2 minutes.
Yes.
All right.
All right. So, as the court knows, this is a divorce case where the trial court made many decisions, but the only issue on appeal today is about the division of marital assets. We are appealing 3 issues: the classification of 30 properties, which I will talk about, the failure of the trial court to place a value on a piece of property, and then the third is the division of property, specifically as it pertains to the marital residence in this case. And I will start with the marital residence because I think that if the court takes any action on that and awards the husband anything, it would change the balance quite a bit. So I will start with that. The marital residence in this case was located at 7270 Ryan Hill Road, and that's how it's referenced in the brief. As the court knows, the findings of fact in appeals cases are de novo with the presumption of correctness, but the conclusions of law is there's no presumption of correctness. It is our position that the trial court's findings of fact, in particular with the Ryan Hill property, were inaccurate, which affected the conclusions of law. First of all, there's no dispute that this marital residence is marital property. The wife listed it in her complaint, in her brief, in the exhibit, it called it marital property. But the court's findings of fact are not supported by the record. First of all, regarding the house, the findings are located at volume 3, page 370 through 371. That is the final decree of divorce where Judge Russell made his findings as to why he did not award any equity to the husband. One thing that he found was, or what he found was that the wife used her separate funds of $70,000 and husband contributed nothing to this house. First of all, there is nothing in the record about $70,000. I'm not sure where the trial court got that number. Volume 5, page 176, the wife testified that she put $200,000 of her own money into the house, but there is no proof of that. I believe that the judge got this confused. The judge relied upon Cronin Wright versus Wright in not awarding the husband any of the equity in the property, and in that case, the wife did use the sum of $70,000 of her own money, so I believe that may be where he was getting the $70,000, because I don't see it, and opposing counsel can correct me if I'm wrong, but I don't see it in the record that there's any testimony about $70,000.
Did the wife testify that she did contribute a certain dollar amount to the property?
She did, Your Honor, at volume 5, page 176. She testified that she put $200,000 of her own money into the house, but there's no proof other than her testimony. But what I think is important is that the undisputed testimony of the husband was that, first of all, there was no mortgage on this house. The parties built this house out of an account that was a daycare account. The wife owned a daycare. It was at that time called House of Knowledge. It's now called Education is the Key. But they used the funds out of that account to build the house. And and that is found at volume 9, page 189. The husband testified that that's where the money came from. Both agree that the husband deposited $120,000 of his own money into that account, and that account was used to then build the house. Now, it was a few years later, but the parties agree, they both consent that the husband deposited his separate funds into that account, which was then subsequently used to build this marital residence at Ryan Hill.
Ms. Butler, do they also agree that that money was used in any way for construction of the home? From my reading of the transcript and the testimony, it indicates that he later withdrew that money and used it for his own purposes that had nothing to do at all with the house. Also, in terms of that $70,000, doesn't the trial court say at someplace else in his oral ruling that it was 80 and that was the amount used to purchase the property in Millington, Tennessee?
It was $25,000 that was used to purchase the property originally. I don't have the citation to the record.
Okay.
$80,000 is, I believe, what the wife claimed in her Rule 14D that she used. What I found in the transcript upon reading is that she testified it was $200,000. And as far as your other question about he used money from that account, I think that is probably true, that is in the transcript. My point is that account they commingled that account, thus turning it into a marital account, which was then used to build this property. I don't think there's any way that we could account dollar for dollar what was used to buy certain things and the house. But the fact is that he deposited that $120,000. He says $125,000. She said $120. We'll go with $120, but he deposited in that. Thus, you know, the account that was used to buy that, to purchase or build that house, was marital property. And even more importantly, the husband actually helped to build this property. Now, the wife disputes that he did a lot, but they both agree that he poured the concrete, and she even acknowledged that he oversaw the contractors. She testified that he would come to her if an electrician or a plumber wanted to get paid. He would come to her, and she would give him the funds out of the account that I was referencing, and he would pay them. But he testified that he put the roof on, he poured the concrete, and he otherwise oversaw the subcontractors. So he did participate in the building of this house. And so, but despite that, we also, I mean, there's no dispute that it's marital property. And we are requesting that the court reverse the court's ruling that he get no equity out of that. The second issue is the 30 pieces of real property from a man by the name of James Love III. In this case, about 8 months before the trial, the wife acquired 30 pieces of real estate. It was not disclosed in discovery. It was filed a month before the trial. It was not disclosed in the wife's Rule 14. We just happened upon it and sent requests for admissions, and finally, the Friday before trial started on Monday, we got the request for admissions, which I have, it's volume 3, 281, page 281, and it has the stamp file date of August 23rd. That was when we first learned that the wife had acquired 30 additional properties during the pendency of the divorce. We believe that the court also made inaccurate findings of fact pertaining to those properties. Number one, he found that there was no, the court's findings are at volume 3, page 371 and 372. He found that wife received no rental proceeds from these properties. But in fact, at volume 7, page 60, wife testified that she and Mr. Love owned an account together. At that time, it was called Education is Key Properties. And if you look at the request for admissions at volume 3, page 281, in the request for admissions, she admitted that she is the managing member of Education is Key Properties. Then on volume 7, page 67, it's, I asked her, so these properties that James Love III transferred to Education as Key Properties produced rental income which goes into Education as Key Properties, and wife answered yes. Volume 7, page 71, the rental income that is received from these properties goes to Education as Key, yes. So the court also found there was no consideration because she didn't pay anything for these properties. The owner of these properties, Mr. Love, did testify that the reason he transferred these to her was because one of his tenants was involved in some type of murder, and he was scared and he wanted to get out of town. So he thought that it would be safe for him to just transfer these 30 properties to her. I find that not to be credible. I don't believe the court really commented on the credibility of this witness, but nonetheless, the court found that these were wife's separate property. The court didn't find that they were a gift. The wife is taking the position that these are gifts. But respectfully, I do not believe that the wife meets the burden of proving that they're gifts, because in order to constitute a gift, there has to be intent to relinquish all control over a property. And the testimony was from Mr. Love that he was always going to get these back. He was just letting her hold them. He wasn't gifting them to her, that he was going to get them back. By the time of trial in August of 2019, he had not gotten them back, but he did not relinquish control over these. And it is the wife's burden of proof to show that property acquired during the marriage is separate, because all property acquired during the marriage is presumed marital. She did not meet her burden of proof. And finally, I'm sorry.
On the gift issue,
Yes.
so are you saying that the court's findings were silent as to whether or not that this was considered a gift? The court found this to be the wife's separate property?
Yes.
But no explanation was provided of whether it was obtained by gift or otherwise?
He just called it her separate property, and the court, the findings said that she was holding this as a favor for a friend, basically, is what the trial court said, but did not specify that it was a gift. So I don't know how the court found that to be her separate property, but it's wife's position it's a gift, and we take the position that she did not meet that burden of proof.
And the court did not make a credibility finding as to any of the witnesses pertaining to this alleged gift, purported gift, whatever you want to call it?
I don't recall that there was any finding about credibility in this case, but I could be corrected about that. But when I reviewed the decree, I did not see that there was. I find Mr. Love to be credible, but he clearly bought his story because he awarded this as her separate property, but didn't define why it was separate property. And the third item is the repurchase of 975 Thomas, which is the daycare building. Once again, this was not disclosed prior to the trial. We did not know that the wife had repurchased this property. At trial, she testified that this is her daycare building. She purchased it for $290,000. She produced a note from First Alliance Bank, which was a legitimate note. But then she came to trial with. She came to trial with a promissory note from Mr. Love, the man who was living in the house with her. This is the father of the man who transferred the 30 properties. It's very confusing, but she produced this note at trial. She did not identify it in her discovery or her Rule 14 that she had a debt to Mr. Love, but she presented a promissory note at trial for $140,000. And if you read the brief, she testified that she didn't know where it came from or where it went, that he paid the bank directly for that. And then when he testified, he said, no, I handed $140,000 cash to her. So we do not believe that that was a credible explanation for that promissory note. But the court did not comment on that property at all. Our problem with that is he just did not make a finding as to the equity or the value that went into the chart, so it throws the marital balance sheet off. And we're requesting that that a value be placed on it, $290,000 minus the legitimate bank note, which is, so it's approximately 140 some odd thousand. That was not placed in the court's balance sheet, and he did not make that finding. So my time is way up. In fact, I don't have very much.
Let me ask you one thing.
Okay.
In connection with the repurchase of the daycare center, the appellee's proof was she had to pay $290. There's a loan from a bank, a mortgage
Yes.
company, and other money supposedly from Mr. Love. During discovery, did you get a copy of the closing papers in connection with that repurchase?
No,
Okay.
we did not.
Thank you. You'll have your rebuttal.
Okay, thank you.
Thank you.
May I proceed? Good afternoon. May it please the court. I'm Attorney Princess Woodard on behalf of the appellee, Dessie X. For the purposes of today's argument, I'll refer to the appellant as Mr. X and the appellee as Ms. X. As this court is aware, for a century, this court has stood as an avenue for relief when trial courts have failed to properly apply the law. This court does not exist to serve as a chance for a second bite at the apple or to provide relief because a litigant is just displeased with the ruling of the trial court. As this court has articulated and reiterated in numerous cases such as Dunlap versus Dunlap, Byrd versus Byrd, and Lancaster versus Lancaster, the trial court is given great deference and a presumption of correctness. While this, of course, is not absolute, a trial court's ruling will only be disturbed if reversible error exists. Reversible error exists when a trial court's division of the marital estate lacks evidentiary support and is contrary to logic and reasoning. In our instant case, reversible error simply does not exist. There was 5 days of testimony. Ms. X provided the majority of trial exhibits. Mr. X only offered his pleadings and evidence regarding his income and his assets into the record. Mr. X offered no tangible evidence to dispute the proof offered by Ms. X. Ms. X testified in addition to offering 2 witnesses to the court, while Mr. X was his only witness. Mr. X first averts that reversible error exists due to the court classifying 30 properties received by Ms. X as her separate property. These properties were transferred to Ms. X 2.5 years into the divorce proceedings. As this court is aware, prior to dividing anything, the court must first classify if it's separate or marital property. Statutorily, property received via gift is a separate property of the receiving spouse. The court, in classifying the 30 properties as Ms. X's separate property, considered several things. One, that the properties were all hastily transferred on the same day, that no consideration was given in exchange for the properties, as well as a testimony of Ms. X and the donee, James Love III. What the court, because there's been brought up that the court did not specify that it was a gift. My assertion is that the court did do that. Our argument on behalf of Ms. X was that these properties constituted a gift. They were separate property. Husband's argument were no, they don't constitute a gift. They're marital property.
Did Mr. Love testify that he had an expectation that the properties were going to be returned to him?
He did have that expectation, Your Honor. And what that then leads us to is if there was actually a proper conveyance, because how can now we have properties that are not going to long-term be Mrs. X's?
Well, how can they be a gift, is my question.
Well, it can't be considered marital. She didn't purchase the property. She didn't do anything to take ownership other than him giving them to her. And while his intent may have been to one day take them back for the purposes she owned them, she was free to do what she sought to do with them.
Did she receive the rents?
She did not receive the rent, and that is in the record. The rents went into an account that she had access to, but she testified that she never utilized any of those funds. That was also corroborated by both James Love III as well as his father, and that does not amount to consideration. This court has held that consideration must be in equivalent value to the items that are being given.
Well, was that, if that's the case, then I know you're taking the position today that they're a gift. Was the court in error in ruling that they were a gift?
I do not believe the court was in error in ruling that they were a gift.
Well, if he had expectations of having them returned, then how can they be a gift?
Well, the delivery happened. So it's just he intended to give her the properties and delivery occurred. So there was he didn't have any force of making her return the properties to him. They became her outright property and they have to be classified. So we contend that they were a gift because there was no consideration in exchange for them.
In the order, does the trial court refer to it as her separate property because it was a gift?
Yes, they assert that it was her separate property because it was a gift.
Yeah, but does the court say it was a gift, or does he just say it's not marital property, it's separate property?
No, what the court says is that there was no consideration given, which gives rise to the belief that the court affirmed that it was in fact a gift, because the court went into detail about if consideration did in fact exist and the nature of why the property was given to Ms. X. I'm sorry, Your Honor. Did you have a question? I saw you.
Oh, that's all right. So what you're saying is that the trial court, then I ask you the same thing I ask your opposing counsel. So as far as a finding of, explicitly finding this is a gift, is the order silent as to the gift nature other than by implication is what you've just stated?
I would agree with that, Your Honor. Implication, the court does expressly state that no consideration was given, which was, again, a premise of our argument that they did constitute gifts because there was no consideration. Okay. Also, we must think, and the argument can be made that if for any reason a court did not conclude that they were gifts, if we just go to the statutory factors of how marital property should be divided, Mr. X did not come to the trial court and say, Ms. X gave anything for these properties, marital funds were used, that I contributed in any certain way, form, or fashion. He knew nothing, and he made no assertions other than to him it was a sham. However, these parties had not talked in many years because of orders of protection and various things. So Mr. X solely came to the court with the assertion that I should get something because it happened while we were married. Not that he had done anything that warranted any type of relief, but just purely that the parties were married when my client did in fact receive the properties.
Well, there is a presumption that any property received during the marriage is marital property, and then the burden is on the other party to prove that it's not marital.
Yes, and what my argument is that we contend it's separate property. Even if for any reason this court or the trial court had conceded or concluded that it was marital property, we would then have had to go to the statutory factors, which the statutory factors would have then not supported Mr. X receiving anything because, again, he didn't make an argument that he contributed anything. He didn't make an argument that there was any basis for him to receive anything from these properties other than she received them prior to the divorce being finalized.
But he didn't have the burden of proof. You had the burden of proof.
Well, I would say he had the burden of proof as far as putting on a case of what's an equitable division. So I'm going into the argument of if they were considered marital property, each party has the burden of proving what is considered equitable. And even though he asserted that they were marital, he made no arguments as to why he was entitled to anything from the properties. The only argument he made was that these are marital, therefore they're part of the marital estate. But when we got to the statutory factors, he offered nothing to support what would be an equitable division. And that applied for the 975 Thomas, that applied for the marital residence. He came to the court with under the idea or the argument that we're married, therefore I'm entitled, which again, there is a presumption that if it's acquired during the marriage, it's marital, but that's not just the end all be all of the law. The law does not say you're married, you automatically get something of everything. This court has numerous cases where equitable is not equal. Equitable does not mean that a spouse receives a share of every asset of the marital estate. We have to go through those factors in under analysis of the facts of the particular case. There was no reversible error here in the court classifying the properties as Mrs. X's separate property. There was no reversible error in Mr. X not receiving anything from any value that may have been associated with the 30 properties.
Let me ask you another question.
Yes.
You bring up an equitable division of the property, and this kind of jumps to another issue on appeal, but how can the court make an equitable division of the property if the court does not place a value, an exact dollar value on everything that's there?
So that has actually been addressed by this court. If you give me 1 minute, I kind of got to jump to that part. I'll find it, but I will say that this court, and it is in my brief, here it is, in Clayton versus Clayton, this court said, although the trial court should place a value on marital assets, it's fair to do so does not necessarily constitute reversible error. So it depends on, based off the facts of the case, if the conclusion can still be drawn that whatever the division was still equitable based off of the facts, it doesn't automatically amount to reversible error because a value was not placed on it. And I'm assuming you're talking about 975 Thomas?
Correct.
Okay, so with 975 Thomas, if you look at the stipulated chart, there was not an issue of what the value of it was. The issue was what it was if there was any equity in it. My client asserted that there was negative equity, approximately $60,000. Husband asserted through his stipulation that there was $17,500 worth of equity, which he affirmed in his reply brief. However, he now comes to the court and says there's $146,000 worth of equity. That was never introduced at the trial court. There was never any argument that there was any equity beyond $17,500 from husband's side. And in the stipulated chart, husband averred the wife should receive that said amount of equity. So now we have a new argument, which this court has also said if you don't argue it at the trial court, you don't get to come to the Court of Appeals and now make a new argument. And that is exactly what's happening. Husband did not, again, only asserted there was $17,500 worth of equity. Husband also stipulated or said that wife could have the property and whatever equity was there. He now says something quite contrary. There's also an argument about when discovery and different things were produced. Husband did not file a motion to exclude. There were no motions in limine. There was no objections with respect to the admission of these things. So I would also argue now, if that is being a premise to say that some relief was not properly granted, then that too is waived because it should have again been addressed at the trial level. Also with 975 Thomas, we concede or we agree that it is it is marital property. But again, husband does not come to the court saying he did anything to contribute to the reacquisition of 975 Thomas. It's not disputed that the parties through mutual actions lost the property, that my client through her independent actions regained the property, that it cost her $290,000 to get the property back. Husband did not come to the court when we're talking about the statutory factors and say, hey, I gave money to get 975 back. I've done any maintenance on 975 since my wife has had it. His only argument was she got it while we were still going through this divorce, so I should get something.
But go ahead. Does the court not have to value the parties' separate property in order to divide the marital estate according to the statute?
The court can, well, do you mean as far as like the 30 properties in this case, or just in?
I mean, you're saying that in looking at valuations and looking at whether it matters and whether it even matters or not, the statute on the number of factors, and I think there's 10 or 12 factors that a trial court has to consider when dividing the marital estate, is one of those not the factor of the value of each party's separate property that they have? They
do look at each party's separate property. But the biggest thing that the court relied on in this case, and I'm going to kind of jump ahead just for time purposes, was the ruling in Cohen-Wright versus Cohen-Wright, which was a short-term marriage. Husband in his reply brief averred that this was not a short-term marriage, but he used the case Velez versus Velez, which was a 12-and-a-half-year marriage. and got classified as long-term. But in that case, that 12 and a half years was from the date of marriage to the date the divorce was actually filed. These parties were only married and cohabitating for 6 years. This was a 3.5-year divorce. So at our closing, we argued Cohen versus Wright applied, which the court adopted that as a roadmap in granting this case. A husband offered no case law, offered nothing in support of any of his assertions other than his testimony. And if you look at the final decree breaks down the facts that the court used the facts that the court used in rendering its ruling, as well as the conclusions of law for how it got there. And what has been determined by this court is if you are able to ascertain how the court got to their conclusion and the evidence does not preponderate against it, then there's no reversible error. And that is simply what happened here. The evidence supports what the court's conclusion was with respect to division of the marital estate. And I have 30 seconds, so I'll just say Ms. X is requesting attorney fees incurred on appeal. Are there any questions for me?
Let me ask you about the conflict in the testimony about money used to repurchase the daycare center. What's your explanation for that conflict?
So there's not conflict on the daycare. There's conflict with respect to the money used for the Ryan Hill marital residence. So
No, I'm talking about the conflict about the difference between the 150 and the 290. Yeah, what Mr. Love did to help her in repurchasing that property. Did that money go to the seller at the time of closing? Was it given to your client in cash, as the appellate's lawyer argued?
So my recollection from the testimony was that there was some confusion there. My client did receive the money, and she did use it to purchase the property. And again, we have 200, and there was the bank records and everything from my client were produced. There wasn't any, astronomical amount of money that she had readily available that she could have utilized independent of getting a loan. And I just returned back to that Mr. X did not come to the court saying that he had done anything. He just came to the court saying that this is classified as marital property, therefore I'm automatically entitled, and the case law and statutes all go against that. It's a fact-based analysis.
Well, how do we track this 140? Did it go to her in cash? Did she deposit into the bank? And then was there some check at closing? I mean, what was the explanation about that?
So the explanation was there was a loan given. The promissory note was produced. I believe Mr. X did testify. No, I'm sorry, not Mr. X. Mr. Love testified that he gave it to my client. My client said it was given to the bank. I'm uncertain if that means that maybe they both appeared at the bank and the money was handed one to the next. But there was a promissory note showing that there was $140,000 given, and there was testimony in support of that. And of course, Mr. X had nothing to do with the reacquisition of the property, so he could offer no testimony because, again, he did nothing in aiding my client in regaining ownership of it.
Yeah, and you say it may have been given to the bank. The bank was not the seller, was it?
I would have to review the record for that, but I believe so. Well, the state took the property, so I do believe the bank was the seller.
Okay, all right.
Thank you.
Thank you.
I see that I have 2 minutes, but I think I went over my time last time. I don't know if the
You
court.
have 2 minutes. We'll give you
Okay.
2 minutes.
Just very briefly, on the 30 properties, they are taking the position that there's no consideration. It's my position there is consideration. She took the properties from him to protect him from crime of some sort. She got, in exchange, properties and rent. She did state in her testimony, volume 3, page 281, volume 7, page 67, that rent did go into an account that she held. As far as the repurchase of 975, we didn't present very much proof on it because we didn't know about it. We learned most of that at trial, that she purchased it for $290, and so where you see the stipulations, there was a stipulation, but we did not know, we did not have the information. It wasn't disclosed in discovery or in the Rule 14, so that's the reasoning for that. Regarding the stipulation, though, in volume 6, page 5, Ms. Woodard and I explained to the judge who required us to do this stipulation document. So we tried to do our best to get that together at the courthouse, and then we presented it him the next day, but we told him, where there is an empty box, we want the court to make a finding as to the value, and there is a box by 975. And Ms. Woodard did state on that page that that needed to be completed. As far as, she said I didn't make any objections. I did make objections. Volume 7, page 98, when she called Mr. Love and Mr. Love the third and the second to talk about these transactions, I objected. I said she's not identified these people as witnesses in her discovery. We just found out about these properties, so I object, but the court let them testify anyway, so I did object. And that's all I have, unless there's any questions for me.
Ms. Butler, that stipulation did not go to every parcel accumulated during the marriage. Is that right? Because the judge does make some statement in his oral ruling that, basically that y'all stipulated to values.
So what we did was there were some properties that we stipulated to values, but that we couldn't stipulate to the division. For example, the marital residence. We stipulated that it was $300,000. We did not stipulate about the division, so we asked the court to rule on that. On the 30 properties, we stipulated to the value, but didn't stipulate to the classification. On 975, we stipulated that it would go to the wife and that it was marital, but we did not have the value. So there were holes in all of these, just different, either classification, value, or division. It just depends on, but that list is a comprehensive list of the property in this case, if that's the court's question. Did I
Okay,
answer
thank you.
that?
Yes.
Okay,
Thank you.
thank you.
Thank you for your argument.
Thank you.